Good morning. My name is Sam Brotman. I am a sales and use tax attorney with Brotman Law here in San Diego. And I wanted to do a short video this morning to clear up a lot of common misconceptions among Amazon sellers. So I've been talking with a lot of people who received notices from California in December, and the January 15th deadline to become registered has now passed. And in a lot of the conversations with Amazon sellers that I'm having, there are some common misconceptions in those conversations, as well as some things that I've seen that are posted online that are not exactly true or that are misleading. So I wanted to post a quick video to get the right information out there and in helping you guys to make some informed decisions with respect to this. So first of all, I would just want to give you an idea of where we're coming from as a law firm with respect to this issue. So even though this is a legal issue, what is of most importance to most people is the business ramifications of this decision. So, and really, our job as a law firm is to help our clients identify, manage, and mitigate risk. So to the extent that we can't mitigate a risk, we need to manage it in the best way possible. And what that means for a lot of Amazon sellers is bringing them into compliance as quickly as possible and as cost effective as possible. So this is really not engaging in a broad, lengthy legal argument about the constitutionality or going down a path that's going to lead to a multi-year litigation. What this is about is helping people get their businesses in compliance, protecting the owners of the business, and protecting the revenue stream that's generated from the business so that the owners and employees can continue to feed their families and do all the things that they do in their business. So let's start with a common misconception that Amazon is a consignor. So in a consignment transaction, there are usually two separate sales. There is a sale to the consignment house, and then there's a sale from the consignee to the person who is purchasing the product. So with Amazon, there's not these two separate sales that are involved. What Amazon is doing is Amazon is holding inventory on behalf of sellers to facilitate shipping. And it's doing that through the FBA platform. And that's what's creating nexus in California under Revenue and Taxation Code 6203. So this isn't a consignment transaction. It's not like you are selling products to Amazon who is then reselling them and taking a fee. Even if that were a case, you as sellers are not collecting resale certificates from Amazon, which would alleviate you from tax in those transactions. Nor is Amazon going to provide you with resale certificates, because if you read the language of your agreement to participate in the FBA program, it will clearly identify you, the seller, as the retailer and not Amazon as the retailer. So it's very clear in the language of that agreement and in the interpretation of the Revenue and Taxation Code that it's the sellers that are responsible ultimately for the tax that's collected and not Amazon. Amazon is simply a marketplace for connecting buyers and sellers of products. So it's like eBay in the sense if eBay was storing inventory, it's like StubHub for tickets. But Amazon is not involved in the sale process between the seller, you, and between your buyer. It is simply facilitating that sale and then taking various fees associated with the facilitation of that sale. And that interpretation is consistent with a lot of the state laws that are passed. So if you look at like a state like Washington that has a marketplace seller's law, it's designed to put the burden of tax collection on the marketplace. But it doesn't interfere with the concept of where the taxable sale is occurring. So for people who are trying to make the argument that Amazon is a consignor, unfortunately, under California law, that's not going to work for the variety of reasons I just explained. The second misconception that I want to clear up is that a legislative or judicial solution will take care of this problem. So as far as on the legislative end, our current federal government is on an extended holiday, and they're not taking up any current legislation that would alleviate this issue. So if there's a hope in the seller community that the federal government is somehow going to intervene in this process, then unfortunately I think you are sorely mistaken there. With respect to California, there's also nothing in the California legislature that is being advanced to either A, shift the burden of tax collections onto Amazon, or B, to eliminate the CDTFA's policy of enforcing this retroactively. So as far as a legislative solution goes, there is nothing that is currently pending that would alleviate this problem. With respect to judicial solutions, there's nothing pending in the California state courts that is in advanced stages that would overturn the CDTFA's policy to go after sellers. So from a state issue, I'm not aware of anything particularly that's going to have an immediate impact on sellers here in California. There are some federal challenges to Amazon's ability to collect tax, most notably the case in South Carolina, where South Carolina is trying to put the burden on Amazon. But relying on this is problematic for two reasons. Number one, the litigation has been delayed, and there's no definitive answer on when we're going to get a district court ruling in this case. It could take years. District court litigation often takes years. And B, even if there is a outcome in district court, it will go presumably to the appeals court and maybe even to the Supreme Court. So this whole process could take a number of years to resolve itself. Litigation is generally a multi-year process, and in the interim, there's nothing preventing California from enforcing the law that's on its books. Keep in mind that the district court challenge in South Carolina is only limited to South Carolina law. There's no broad applicability of the law in California. So assuming you get a favorable decision in South Carolina, somebody's going to have to take that and go and enforce that in California. And California and South Carolina are on opposite sides of the country, and they're in two separate federal circuits. So even if there is a successful challenge in South Carolina that's upheld by the district court, that's upheld by the appeals court, someone would have to bring a similar challenge in California, win in district court in California, and then prevail in the Ninth Circuit here. So there is a very real possibility, number one, that you could have a circuit split between the two circuits, and number two, that could be a multi-year process. It's not like South Carolina is going to win its challenge and there's going to be amnesty for Amazon sellers. So I want to be very clear in how that works. There have been some other people online who are advancing the concept of pursuing a class action against Amazon. Number one, you would need a solid legal basis to enforce a collection challenge against Amazon, which a lot of people are going to rely on the Constitution and the Commerce Clause. But secondly, any concept of a class action against Amazon would most likely be litigated and defended by Amazon. Amazon is a multi-billion-dollar corporation and has a variety of legal resources. So a challenge from a legal perspective would be a tall order against Amazon. Not to say that it couldn't ultimately prevail, but it's a very time-consuming and expensive process and is going to consume a lot of resources on one side. Not to mention the fact that with any sort of litigation, either the South Carolina litigation or any proposed class action, there exists the possibility for settlement. So it's not like a class action lawsuit is necessarily going to make it all the way through and there's going to be a magic decision that's going to alleviate the retroactivity of these sales and use tax laws. So from a risk mitigation perspective, I don't think it is a particularly good idea to hold your breath on a legislative or a judicial challenge because of the timing and the difficulties involved. And keep in mind, even if there's a challenge in another state, that doesn't have any bearing on the California Department of Tax and Fee Administration to go pursue this against sellers. The last misconception I want to clear up is this concept of a wait-and-see approach. There's a number of practitioners out there who, frankly, are unfamiliar with the way the Department of Tax and Fee Administration works in California, but who are advocating this, well, let's wait till they come after you approach. If you look at the history of California's out-of-state compliance efforts, and California is one of the more robust, if not the most robust states in terms of pursuing people outside its borders who owe potential sales and use taxes and state income taxes. California actually has 3 branch offices that are set up outside of California, one in Houston, one in Chicago, and one in New York City, that they use as regional jumping off points. And California has really developed a very efficient way to go after out-of-state sellers. So to give you an idea, we do mostly California-based sales and use tax controversies as well as state income tax controversies. We're really known as a California tax controversy firm. And my personal practice if you'd asked me in 2014, I would have told you that I'm going to represent 100% California clients, and that's all I'm going to do. But really, in reality, our practice has shifted, so about 40 to probably even 50% of our practice now is representing people who are outside of California that have stepped into California. So those are not all Amazon sellers, but it should give you an idea just on the frequency that we're experiencing it as a firm on how active California has been in pursuing out-of-state collections. California is not going to go away. The statutes here are written, unfortunately, not in the favor of people who are out of state and owe money. And they're written in a way to facilitate the Department of Tax and Fee Administration in their assessment and collection efforts. So a lot of people are ignoring the January 15 notice and hoping that California is going to go away. And unfortunately, that's probably not going to be the case. What happens when you receive a notice like that is there's the opportunity to come forward and to get into compliance. And if you don't come into compliance, you'll go down another path. You get assigned to a tax collection or a tax compliance officer. And then if you don't respond to that tax compliance officer, you either potentially will subject yourself to an audit, or California will just issue an assessment and make you fight the assessment. So there's nothing preventing from California, absent a filed sales tax return, from issuing an assessment for that same quarter. And when you don't file a sales tax return in California, there's an unlimited statute of limitations. And on the collection side of things, California has a 20-year collection statute, and sometimes up to 30 years, to enforce collection efforts against sellers. So even though you say, well, I'm in New York, I don't have any property or anything that California can touch, number one, you do business on Amazon. Amazon has nexus in California. So Amazon can easily be levied. California can, without leaving the state, California can go in and levy your Amazon merchant account and take all the proceeds out of there. Number two, if you use any sort of national banking or credit card processing or things like that, most notably those entities will have some sort of nexus with California, and California can do the same thing. So just don't think that because there's a distance between you and California that California can't enforce collection actions, and those actions aren't authorized by our state statutes here. So I realize the unfairness of this. I realize that a bunch of people in the Amazon seller community have inadvertently triggered nexus in California, and the concept of that you guys should be aware of the laws in California or in any other state where there's economic nexus or some other nexus is patently unfair. But the problem is that this is representative of a change, and you can't think of yourself as just a corporation in your home state. You have to start thinking about yourself as a multi-state corporation, which is essentially what you guys are. You guys, unknowingly or not, have triggered nexus in a variety of states, and you're going to have to come into compliance. So by delaying the decision to come into compliance, you're really prolonging the agony that you potentially may go through. As more states get more sophisticated and start assessing and moving towards collection efforts, this is going to be a multi-front problem. So I really want to encourage you to get some help, to get some good guidance, to talk to people who are either in California or who have a real knowledge of the revenue and taxation code here in California and how the CDTFA procedure really works and how they're structured. Because really, as I said earlier, this is ultimately a business decision. Is you guys are being forced into compliance, and the idea is to get into compliance for the least amount of cost and with the least amount of hassle possible. And that's the approach that we've been taking with a number of our clients, and that's the approach that I would encourage you to take in trying to deal with this problem. So if you have any questions, you're more than welcome to reach out to us. Our website is www.sambrotman.com. You can also reach us via email at lawoffice@sambrotman.com, or you can call our main office line, which is 619-378-3138. I'm more than happy to sit down with you in a consultation and look at the specifics of your business and help you identify and manage and mitigate your risk. So thank you very much for joining me this morning. If you have any questions, please reach out to us, and I look forward to speaking with you very soon. Thank you so much. Talk to you later. Bye.